87, entitled Request for an Advisory Opinion of the International Court of Justice on the Legal Consequences of Separation of the Chagos Archipelago from Mauritius in 1965. The Assembly has before it a draft resolution issued as document A/71/L73. I now give the floor to the distinguished representative of the Congo to introduce on behalf of the Group of African States draft resolution A/71/L73.
Mr. President, pursuant to the inclusion of item 87 on the agenda of the United Nations General Assembly in September last, I have the honor to introduce on behalf of the 54 African states to the United Nations a draft resolution entitled Request for an Advisory Opinion of the International Court of Justice on the Legal Consequences of the Separation of Chagos Archipelago from Mauritius in 1965, under the said item 87 and bearing reference A/71/L73. Mr. President, the action initiated by the African states in collaboration with the government of Mauritius at the level of the United Nations is in pursuit of the effort of all African states, including Mauritius, to complete the decolonization of Africa and to allow a states member of both the African Union and the United Nations to exercise its full sovereignty over the Chagos Archipelago in accordance with international law and the right of self-determination. The present submission echoes the African Union resolution on Chagos Archipelago Assembly/AU Res.1 Roman 28, which stipulates that the excision of Chagos Archipelago from the territory of Mauritius by the former colonial power prior to the independence of Mauritius is unlawful and, as a result, is a violation of international law and especially UN Resolution 1514 Roman 15 of 4th of December 1960 and 26 Roman 20 of 16 December 1965, which prohibits colonial powers from dismembering colonial territory prior to granting independence. In addition, UN General Assembly Resolution 1514, Roman 15, specifies that any attempts aimed at the total or partial disruption of the national unity and the territorial integrity of a colonial country is incompatible with the purposes and principles of the UN Charter. Furthermore, UN General Assembly Resolution 2066, Roman 20, which deals specifically with Mauritius, had called upon the United Kingdom to take no action which would dismember the territory of Mauritius and violate its territorial integrity. The then administering power was invited to comply with the provisions of the resolutions and to take effective measure with a view to the immediate and full implementation of Resolution 1514 Roman 15. More than 5 decades have passed, and despite continued and repeated appeals made in international fora, including at the United Nations, the Chagos Archipelago is yet to be returned to the effective control of Mauritius by the former administrative power. Mr. President, in the resolution adopted by the Assembly of the African Union in July 2015, January 2017, respectively, Following previous pertinent ones, the African heads of state and government had reiterated their support to the Republic of Mauritius in its endeavor to complete its decolonization and effectively exercise its sovereignty over the Chagos Archipelago. In this context, following a request from the government of the Republic of Mauritius that was actively supported by the African Group, the United Nations General Assembly has decided to include on the agenda of its current session an item entitled Request for an Advisory Opinion of the International Court of Justice on the legal consequences of the separation of Chagos Archipelago from Mauritius in 1965. However, at the request of the United Kingdom, the Republic of Mauritius has agreed that consideration of this item be deferred until June 2017. This item was included by consensus by the General Assembly on its agenda following an understanding between Mauritius and the UK, facilitated by the President of the UN General Assembly, to defer, at the request of the UK, the consideration of the item until June 2017 in order to allow time to the concerned delegation to reach a solution on the completion of the decolonization of Mauritius. Unfortunately, there has been no progress in this discussion since there was no wish from the other party during the talks to focus on the central issue of decolonization, so essential to a successful outcome of the process. Therefore, it was clear that there could not be no prospect of progress. Mr. President, the draft resolution bearing reference A/71/L73 calls on the General Assembly to decide, in accordance with Article 96 of the Charter of the United Nations, to request the International Court of Justice, pursuant to Article 65 of the Statute of the Court, to render an advisory opinion on two issues. One, was the process of decolonization of Mauritius lawfully completed when Mauritius was granted independence in 1968, following the separation of Chagos Archipelago from Mauritius in contravention of international law and UN General Assembly resolution? And two, what are the consequences under international law arising from the continued administration by the United Kingdom of the Chagos Archipelago, including the inability of Mauritius to implement program for the resettlement of the Chagos Archipelago of its nationals, in particular those of Chagosian origin? Mr. President, as everyone is aware of, the right to self-determination and the completion of the decolonization process continue to be a central concern of the United Nations as a whole. That is why we firmly believe that the United Nations would benefit from the guidance of a principal judicial organ of the United Nations on the decolonization process with respect to the two questions posed in the draft resolution. An advisory opinion from the International Court of Justice would assist the General Assembly in its work and would contribute to the promotion of the international rule of law. Noting that no progress has been made since the issue of Chagos Archipelago was on the UN agenda for more than 5 decades, and in conformity with the principle of justice and international law, the group of African states to the United Nations calls on all member states to vote in favor of the draft resolution, A/71L73. The resolution is nothing but a request for an advisory opinion of the International Court of Justice on the legal consequences of the separation of Chagos Archipelago from Mauritius in 1965. A yes vote will be a vote in favor of the principles of the UN Charter that continue to guide the organization effort in the principle of self-determination. The UN cannot continue to ignore Mauritius' cry for justice. I thank you.
And I thank the distinguished permanent representative of the Congo. I now give the floor to the distinguished representative of Mauritius, Sir Anirudh Jugnauth.
Mr. President, my delegation would like to associate itself with a statement which has just been made by the permanent representative of the Republic of Congo on behalf of the African group of states members of the African Union. I am accompanied by Mauritians of Chagos origin who were forcibly evicted from the Chagos Archipelago and who are putting all their hopes in the United Nations to uphold their ability to return to the archipelago, which the complete decolonization of Mauritius will allow. Mr. President, I have been privileged to witness my country's political advancement and was one of those, now the only survivor, who participated in the Mauritius Constitutional Conference held in London in 1965, and which was meant to pave the way for the independence of Mauritius in 1968. I am therefore personally aware of the circumstances in which the Chagos Archipelago was excised from the territory of Mauritius prior to independence. The Chagos Archipelago has been part of the territory of Mauritius since at least the 18th century, at a time when Mauritius was a French colony. Throughout the period of French colonial rule, France governed the Chagos Archipelago as one of the dependencies of Mauritius. All the islands forming part of Mauritius, including the Chagos Archipelago, were ceded by France to the United Kingdom in 1810. The administration of the Chagos Archipelago as a constituent part of Mauritius continued without interruption throughout the period of British colonial rule until its unlawful excision from the territory of Mauritius on the 8th November 1965. No one today can challenge that fact. Their excision was carried out in blatant violation of international law and UN General Assembly resolutions 1514 15 of 14th December 1960, containing the declaration on the granting of independence to colonial countries and peoples, which called for a speedy and unconditional end to colonialism. That declaration clearly stipulated that any attempt at the partial or total destruction of the national unity and the territorial integrity of a country is incompatible with the purposes and principles of the Charter of the United Nations. Further, the wrongfulness of the excision was recognized and confirmed in General Assembly Resolution 2066-20 of 16th December 1965, in which the General Assembly called upon the UK government to take effective measures with a view to the immediate and full implementation of Resolution 1514 and to take no action which would dismember the territory of Mauritius and violate its territorial integrity. Such views were reiterated in General Assembly Resolution 2232-21 of 20th December 1966 and Resolution 2257, bracket 22 of 19th December 1967. The decolonization process of Mauritius and the General Assembly's supervision thereof therefore remain incomplete. More than 30 years after the excision of the Chagos Archipelago, shocking truth about the circumstances of the dismemberment of the territory of Mauritius came to light. For so many years, the United Nations and the world indeed were unaware of such facts, namely internal Foreign Office memos of 1965 and 1966 showing a deliberate intent to present the United Nations with a fait accompli and to mislead it about the permanent nature of the population who lived in the Chagos Archipelago. The Chagosians were cynically referred to as Tarzans and Men Fridays. To avoid the scrutiny by the United Nations about the illegality of the dismemberment of the Mauritian territory and the eviction of the population living in the Chagos Archipelago, it is today appropriate to recall what was stated back in 1965 by the UK Colonial Secretary to the UK Prime Minister. He said, and I quote, "It is essential that the arrangement for detachment of these islands should be completed as soon as possible. From the United Nations point of view, the timing is particularly awkward. We are already under attack over Aden and Rhodesia. We shall be accused of creating a new colony in a period of decolonization. If there were any chance of avoiding any publicity until this session of the General Assembly adjourns at Christmas, there would be advantage in delaying the order in Council until then. But to do so would jeopardize the whole plan. Moreover, we should lay ourselves open to an additional charge of dishonesty if we evaded the defense issue in the fourth committee and then made the order in Council immediately afterwards. It is therefore important that we should be able to present the UN with a fait accompli." End of quote. Delegations present here should find in these facts alone a compelling reason for the UN to be given today an opportunity to have a fresh look at the propriety of the acts done in 1965. The draft resolution is not a belated wake-up call from Mauritius, as suggested by some. It addresses colonialism and decolonization, a matter of interest to all members of the organization as a whole. Mauritius has never missed any opportunity as soon as its socio-economic circumstances permitted it to do so, and in light of those shocking truths, to voice its opposition in international fora, including the UN General Assembly. There has also been continued and sustained international condemnation of the dismemberment of Mauritius, of the illegal excision of the Chagos Archipelago, or the continuing colonial legacy, including by the Organization of African Unity and subsequently the African Union, the Non-Aligned Movement, the Group of 77, and China, the African Caribbean Pacific Group of States, and the Africa-South America Summits. Mr. President, the dismemberment of the territory of Mauritius without the freely given consent of Mauritius in circumstances of patent and obvious duress, and the removal of the inhabitants of the Chagos Archipelago with no possibility of return were acts constituting breaches of peremptory norms of international law, namely the violation of the principle of self-determination and the breach of fundamental principles of human rights. No amount of monetary compensation and no agreement to that effect can override these general principles of peremptory international law, not the least the right of self-determination. Mr. President, Mauritius, prior to its independence in 1968, had no legal competence as a state to give any consent to the detachment of the Chagos Archipelago from its territory. It was a mere colony and had a colonial governor and lacked capacity to consent to detachment. It is obvious that it could not legally consent, even if, as the UK's position seems to be, some form of consent was given in return for monetary compensation. The excision was incompatible with the provisions of the United Nations Charter as interpreted and applied by pertinent resolutions of the General Assembly. Consent, if any, of the colony of Mauritius could not validate breaches of the Charter. Moreover, Mauritius, as an independent sovereign state, has never entered into any agreement pertaining to such detachment. I need not say more. I hope I have persuaded you that arguments being put forward in support of a no vote and based upon such previous consent or financial compensation do not stand under international law. Mr. President, under your wise stewardship, the consideration of item 87 was deferred at the United Kingdom's request until June 2017 in order to allow Mauritius and the United Kingdom to engage in talks aimed at the completion of the decolonization process of Mauritius. 3 rounds of talks have been held between Mauritius and the United Kingdom. However, these talks became pointless as the United Kingdom was unwilling to discuss a date certain for the completion of the decolonization of Mauritius. It was unwilling even to talk about decolonization. The position that the administering power brought about in 1965 remains unchanged today. Consequently, as there is no prospect of any end to the colonization of Mauritius, the General Assembly has a continuing responsibility to act. More than 5 decades have passed, and now is the time to act. It is fitting for the General Assembly to fulfill that function on the basis of guidance from the International Court of Justice as to the legality of the excision of the Chagos Archipelago in 1965. The draft resolution before the General Assembly contains 2 legal questions which are linked to the issue of decolonization. A matter of direct interest to the General Assembly, an advisory opinion will no doubt contribute significantly to the work of the General Assembly in fulfilling its functions under chapters 11 to 13 of the United Nations Charter. Different views of one or more states on the legality of the excision of the Chagos Archipelago in 1965 do not make of the excision a mere bilateral matter. The International Court of Justice has made this absolutely clear, including in recent opinions on Kosovo and on the war. Rather, this matter concerns a need for guidance from the International Court for the General Assembly on an important matter of decolonization. Bilateral talks seeking to address this matter simply are not a basis for denying the multilateral interest in the matter. Member states of the United Nations have the collective responsibility to uphold the principles enshrined in the UN Charter. The Declaration on the Granting of Independence to Colonial Countries and Peoples and all relevant resolutions. In doing so, we shall be upholding the integrity and authority of institutions which we have created, in particular the General Assembly, and the General Assembly's continued responsibility in completing the decolonization process, which started in the 1950s, should not be thwarted by arguments not in line with international law. Some of our friends are arguing a vote against the draft resolution for reasons that are not valid. These reasons are not for the General Assembly to decide, and they can in any event be raised, if they wish, in proceedings before the International Court of Justice in due course. Besides, breaches of principles of international law and General Assembly resolutions remain breaches that can never validly be acquiesced in or consented or traded off with money. These breaches and the issues of colonization and decolonization are of interest to the whole international community. They cannot ever be waved away as merely bilateral, as the administering power would want member states to believe. Likewise, our friends have invoked security concerns, which they claim may be endangered. Let me make it clear that there is no threat to peace and security by seeking an advisory opinion. Simply asking these questions to the court does not prohibit specific states from continuing to hold different views on the answer to the questions. Mauritius is also very much concerned about security in the world, and that is why we have repeatedly said that we do not have any problem with the military base, but that our decolonization process should be completed. We want to assure the United Kingdom and the United States of America that the exercise of effective control by Mauritius over the Chagos Archipelago would not in any way pose any threat to the military base. Mauritius is committed to the continued operation of the base in Diego Garcia under a long-term framework which Mauritius stands ready to enter into with the concerned parties. The vote on the draft resolution before the General Assembly would be a vote in support of completing the process of decolonization, respect for international law and the rule of law, and respect for the international institutions which we member states of the United Nations have created. It is also a vote of confidence in the ICJ, the principal judicial organ of the United Nations. My delegation, therefore, urges you, through your vote for the draft resolution, to send a signal that your delegation, and indeed your state, supports international law and the rule of law. Mr. President, let me now briefly recapitulate the salient points of our position. 1. The Chagos Archipelago has always formed and continues to form an integral part of the territory of Mauritius. 2. The displaced inhabitants of the Chagos Archipelago had lived there for many generations. 3. The issue of dismemberment of Mauritius has repeatedly been invoked at the annual meetings of the General Assembly and in other UN bodies, as well as in other international fora, such as the OAU, AU, NAM, and G77. 4th, the UK has refused to address decolonization during recent talks. 5th, UK proposals during the talks were manifestly inadequate, failing to address the completion of the decolonization of Mauritius. 6th, the subject of the request for an advisory opinion of the International Court of Justice does not relate to a bilateral dispute. 7th, the mere request for an advisory opinion does not have any bearing on or adversely affect the security interests of any other state. Eighth, it is for the International Court of Justice to address outstanding questions as to the basis for the request for an advisory opinion. Ninth, a yes vote on the draft resolution will uphold the institutions of the UN, assist the General Assembly, and support the principles of the UN Charter and the international rule of law. Just like item 87 was included by consensus on the agenda of the General Assembly, we would hope that the draft resolution can be adopted in the same manner. Let us allow the United Nations to fulfill its mandate as regards decolonization. I was in London in 1965. 52 years later, I invite all members to join in signaling that now is the time for the right of self-determination to be recognized and for the rule of law to prevail. I believe that it is the collective responsibility of all of us as members of the United Nations to support this draft resolution. Thank you, Mr. President.
And I thank the distinguished representative of Mauritius for his statement. And I now give the floor to the distinguished permanent representative of Venezuela, who will speak on behalf of the non-aligned movement.
Señor Presidente,
Mr. President, I have the honor of taking the floor on behalf of the movement of non-aligned countries. First of all, allow me to express our gratitude for convening this plenary session, which is devoted specifically to the consideration of the draft resolution A/71/L73, entitled Request for an Advisory Opinion of the International Court of Justice on the Legal Consequences of the Separation of the Chagos Archipelago from Mauritius in 1965, which was submitted by the Republic of Congo on behalf of the African Group. Mr. President, the founding principles of the movement of non-aligned countries are rooted in its rejection of colonialism. The fight for liberation was the main factor which brought together the new independent states of Africa, Asia, and Asia-Pacific and Latin America. The support of the non-aligned movement for decolonization initiatives has remained and continues to be unwavering. As we draw closer to the end of the third decade for the eradication of colonization, the need to free peoples from the shackles of colonialism has become even more pressing and critical. In this respect, I would like to recall the position which was agreed to by the heads of state or government during the 17th summit of the movement of non-aligned countries held in Margarita Island, Venezuela, on the 17th and 18th of September 2016. The heads of state and government reaffirmed that the Chagos Archipelago, including Diego Garcia Island, which was illegally removed from the territory of Mauritius by the former colonial power, in breach of international law as well as the UN resolutions 1514, Roman 15, of the 14th of December 1960, and 2066, Roman 20, of the 16th of December 1965, are an integral part of the territory of the Republic of Mauritius. The heads of state and government observed with great concern that despite the strong opposition expressed by the Republic of Mauritius, the United Kingdom intended to establish a marine protected area around the Chagos Archipelago, thus violating even further the exercise of sovereignty of the Republic of Mauritius over the Chagos Archipelago, as well as the exercise of the right of return for the Mauritian citizens who were forcibly removed from the archipelago by the United Kingdom. In this respect, they welcomed the verdict of the arbitration tribunal in the case presented by the Republic of Mauritius against the United Kingdom under the UN Convention on the Law of the Sea, and according to which the marine protected area was established illegally in accordance with international law. The heads of state and government noted that on the 18th of March 2017, following the proceedings begun by Mauritius against the United Kingdom under the UN Convention on the Law of the Sea to challenge the legality of the marine protected area, the arbitration tribunal established in accordance with Annex 7 of the UN Convention of the Law of the Sea, and they ruled unanimously that the MPA violated international law. Mindful of the fact that the government of the Republic of Mauritius is committed to take all the necessary measures to affirm the territorial integrity of the Republic of Mauritius and its sovereignty over the Chagos Archipelago under international law, the heads of state and government decided to fully support these measures, including any action which could be undertaken in this direction in the UN General Assembly. Mr. President, the movement of non-aligned countries, in line with the positions adopted by the heads of state and government during the 17th summit of Margarita Island, appeals to all of the member states of the movement to support the action begun by the African group under Agenda Item 87 of the UN General Assembly. Thank you very much, Mr. President.
I thank the distinguished permanent representative of Venezuela speaking on behalf of the non-aligned movement, and I now give the floor to the distinguished permanent representative of Angola, who will speak on behalf of the Southern African Development Community.
Mr. President, distinguished delegates, I have the honor to speak on behalf of the 15 United Nations member states who are members of the Southern African Development Community, SADC, namely Angola, Botswana, the Democratic Republic of the Congo, Lesotho, Madagascar, Malawi, Mauritius, Mozambique, Namibia, Seychelles, South Africa, Swaziland, Tanzania, Zambia, and Zimbabwe. This statement is being delivered in connection with Item 87 entitled Request for an Advisory Opinion of the International Court of Justice on the legal consequences of the separation of the Chagos Archipelago from Mauritius in 1965, unquote, and under which a draft resolution bearing reference A/71/L.73 has been tabled by the African Group this morning. We also wish to align ourselves with the statements delivered just now by the distinguished ambassadors of Congo and Venezuela on behalf of the African groups and the states members of the non-aligned movement, respectively. Mr. President, the precursor organization of the Southern African Development Community, namely the Frontline States, was formed in 1976 with the objective of assisting the Southern African countries to achieve independence both politically and economically. Although SADC has emerged today as among one of the strongest regional economic blocs on the African continent, we have not foregone the primary objective for which this organization was established. As a region, SADC member states have experienced colonialism in different forms and had lived through periods of minority governments which had catered to external interests rather than to the needs of the local people. In spite of all odds, challenges and pressures, we stood by the side of our brothers and sisters in Southern Africa to accompany them in their journey towards freedom and liberation. Today, African Union is knocking at the door of the United Nations to request for an advisory opinion from the International Court of Justice on the legal consequences of the separation of the Chagos Archipelago prior to granting independence to Mauritius in 1965. It is therefore our moral duty as SADC to support the African Union in its endeavor to bring about the completion of the decolonization of Mauritius and enable the exercise of effective control by Mauritius over the Chagos Archipelago. Mr. President, the Chagos Archipelago was illegally excised from the territory of Mauritius prior to its accession to independence in a blatant breach of international law and UN Resolution 1514 of 14th of December 1960. UN General Assembly Resolution 2066, 20, Roman 20, adopted on 16th of December 65, which deals specifically with Mauritius, had called upon the United Kingdom to take no action which would dismember the country of Mauritius and violate its territorial integrity. Nonetheless, the then colonial power proceeded with the dismemberment of the territory of Mauritius prior to its independence, an action that was clearly incompatible with the purposes and principles of the United Nations Charter. Mr. President, SADC has consistently supported Mauritius in its endeavor to exercise its full, effective control over the whole of its territory, which includes the Chagos Archipelago. The SADC Summit's declarations adopted in August 2014 and August 2015 had firmly committed to all actions undertaken by Mauritius to complete its decolonization and, I quote, endorsed international calls for the United Kingdom to expeditiously end its unlawful occupation of the Chagos Archipelago, including Diego Garcia, with a view to enabling Mauritius to effectively exercise its sovereignty over the archipelago, without which the full decolonization of Africa is not complete. End of quote. Mr. President, SADC Group is of the view that the continued occupation of the Chagos Archipelago constitutes a challenge to the principles of these United Nations, as freedom, justice, and dignity were the foundation of the United Nations and its institutions. Any action that denied another nation those rights is deemed to be actually undermining the collective conscience and noble principles of the organization. Mr. President, defending and supporting the right to self-determination and completion of the decolonization process has always been a cardinal principle of SADC. True to that principle, SADC member states will vote in favor of the draft resolution A/71/L73 entitled Request for an Advisory Opinion of the International Court of Justice on the legal consequences of the separation of the Chagos Archipelago from Mauritius in 1965, quote, and earnestly call all member states to also support the draft resolution to uphold the principle of the United Nations Charter and international law. Thank you, Mr. President.
And I thank the distinguished permanent representative of Angola, who was speaking on behalf of the Southern African Development Community. I now give the floor to the distinguished permanent representative of the United Kingdom.
Thank you, Mr. President. Last September, Mr. President, you asked the United Kingdom and Mauritius to engage in bilateral talks about the Chagos Archipelago, which the United Kingdom administers as the British Indian Ocean Territory. We have done that in good faith. Only this week, our new Minister for the United Nations, Lord Ahmed, flew to New York to continue the bilateral dialogue and to meet the Minister Mentor of Mauritius, whose eloquent speech we have just heard. You were right, Mr. President, to ask us to talk bilaterally. We should, as a rule, talk bilaterally to try to settle bilateral differences, and questions on the British Indian Ocean Territory have long been a bilateral matter between the UK and Mauritius. And we firmly hold that these questions should remain a bilateral matter. So I regret that this issue has come to the General Assembly. It saddens us that a dispute between two UN members, two Commonwealth partners, should have reached this chamber in this way. A more constructive path is still available, and I call for the withdrawal of this draft resolution to keep that path open. Despite the terms of the draft resolution, this is not a matter of decolonisation. Mauritius became independent in 1968 through mutual agreement between the Council of Ministers of Mauritius and the UK government. In separate talks with the Council of Ministers, Mauritius had earlier accepted the detachment of the Chagos Archipelago, an agreement that Mauritius continued to respect until the 1980s. The General Assembly has not discussed this matter for decades. And yet here we are today returning to the issue. Just think, how many other bilateral disputes left over from history could be brought before the General Assembly in this way? The present draft resolution could set a precedent that many of you in this hall could come to regret. We do not doubt the right of the General Assembly to ask the ICJ for an advisory opinion on any legal question. But the fact that the General Assembly has not concerned itself with this matter for decades shows that today's debate has been called for other reasons. Put simply, Mr. President, the request for an advisory opinion is an attempt by the government of Mauritius to circumvent a vital principle, the principle that a state is not obliged to have its bilateral disputes submitted for judicial settlement without its consent. And let me be clear, we do not and we would not give that consent because we are clear about what was agreed with Mauritius. If the draft resolution were passed, the court would of course have to decide whether it could properly respond to the request. Our view is that it could not do so, as it concerns a bilateral dispute between two member states. Many of you here today have told us privately that you too see this as bilateral business and have urged us to use bilateral means to resolve it. So in turn, let me urge all of you who have told us this, and not only you, to vote against the draft resolution today. In particular, any of you planning to abstain because this is bilateral, please vote no, precisely because this is bilateral. We have made every constructive effort to engage and encourage the government of Mauritius not to proceed with this plenary meeting today. Precisely because it is a bilateral matter, we entered into bilateral talks in good faith, determined to make them work. Since September, we have had 3 substantive rounds of talks, and as I said, we held discussions with Mauritius at ministerial level here in New York this week. Despite every effort by the UK, we have not yet succeeded in bridging the differences between us. I regret this, but we remain committed to bilateral discussion. This Assembly should also know that we have made significant offers to Mauritius. In 1965, we made a binding commitment to cede sovereignty of the Chagos Archipelago to Mauritius when the archipelago is no longer needed for defence purposes. In the recent bilateral talks, our offers to Mauritius signalled very clearly that we acknowledge Mauritius's long-term interest in the archipelago, and we used the talks to try to increase mutual confidence between us on those very matters that divide us. So we offered, without prejudice to our sovereignty, a framework for the joint management in environment and scientific study of all the islands of the territory except for Diego Garcia. And we offered strategic and tactical forms of bilateral security cooperation. These offers were relevant to the dispute and were seriously made. I regret that Mauritius did not engage on them, because they could have made a big difference to our mutual confidence, and they would give Mauritius a more tangible and direct stake in the archipelago than it has ever had. It was a surprise to us, Mr. President, to see that the draft resolution links the former inhabitants of the Chagos Archipelago, the Chagosians, with our sovereignty. It's a surprise because Mauritius has not made more than a passing reference to the cause of Chagosians during all our bilateral talks. The Mauritian focus throughout the talks was its demand for a transfer of sovereignty. Nevertheless, the welfare of Chagosians is an extremely important matter and a real concern to us, and I want to be clear about my government's position. Like successive governments before it, the present UK government has expressed sincere regret about the manner in which Chagosians were removed from the British Indian Ocean Territory in the late 1960s and early 1970s. And we have shown that regret through practical action and support for the Chagosians ever since. In 1973, the then British government gave funds directly to the government of Mauritius to assist with their resettlement. In 1982, a further payment was made through a trust fund. More recently, we have considered very closely the matter of resettlement. We commissioned an independent feasibility study and undertook a public consultation. These found that there is an aspiration among some Chagosian communities for resettlement, but demand appears to fall substantially when those consulted understand more about the likely conditions of civilian life on what are very remote and low-lying islands. The government has considered all the available information and has decided against resettlement on the grounds of feasibility, cost, and defence and security interests. While we have ruled out resettlement, we are determined to address the Chagosians' desire for better lives, their desire for connections with the territory. So we are implementing a $50 million support package, which is being designed to improve Chagosian livelihoods in the communities where they now live, in Mauritius, the Seychelles, and the UK. We've already consulted Chagosian groups in all 3 countries and will continue to do so. As I say, Mr. President, the Mauritian focus throughout the talks has not been the Chagosians, but Mauritius's claim for sovereignty over the Chagos Archipelago. The government of Mauritius has repeatedly pressed us to specify a date for the transfer of sovereignty. We have explained to them why we cannot do this. We made an agreement in 1965, and the UK is standing by that agreement. We created the British Indian Ocean Territory for defence purposes, and in 1966 concluded an agreement with the United States of America for joint defence use of the territory. the extensive facilities that have since been established are primarily used as a forward operating location for aircraft and ships, and they make an essential contribution to regional and global security and stability. Moreover, they contribute to guaranteeing the security of the Indian Ocean itself, from which all neighbouring states benefit, including Mauritius. The facilities play a critical role in combating some of the most difficult and urgent problems of the 21st century, such as terrorism, international criminality, piracy, and instability in its many forms. Our current agreement with the United States lasts until 2036. We cannot, 19 years away, predict exactly what our defence purposes will require beyond that date. We should not and will not make arbitrary or ill-informed or premature decisions. We cannot gamble with the future of regional and global security. Mauritius's attempted assurances on the base's future lack credibility. In contrast, the UK stands by its commitment. When we no longer need the territory for defence purposes, sovereignty will pass. And that, by the way, is exactly what we did in relation to the very similar agreement reached with the Seychelles in 1965. We ceded sovereignty of islands to the Seychelles when we no longer needed them for defence purposes. In our dealings with Mauritius, we have tried to set out bilateral relations on a positive future path, rather than focus on the past. But we should be clear about the past. The simple fact is that we negotiated the detachment of the Chagos Archipelago with the elected representatives of Mauritius, the same people with whom we were separately negotiating the independence of Mauritius. The representatives of the Mauritian people had authority to negotiate with us in both negotiations, and in both cases they reached agreements with us. On the detachment of the Chagos Archipelago, they negotiated first compensation, which we paid, second various rights for Mauritius, and third this long-term commitment to cede the islands to Mauritius when no longer needed for our defence purposes. Our promise to cede sovereignty of the islands to Mauritius when they are no longer needed for defence purposes is not a sign that we lack confidence in our sovereignty. On the contrary, we were and we remain confident about our sovereignty. In its recent arbitral award, the UNCLOS Tribunal found that it had no jurisdiction to rule on Mauritius's sovereignty claim, contrary to what Mauritius has sought to imply in its notes to members of this Assembly. In 1965, we undertook to cede the territory in due course because we were setting it up for a specific purpose but could envisage a future situation in which the territory might no longer make a useful contribution to defence purposes. That moment has not yet come. The base is playing a vital role. Until the moment does come, and subsequently, we want to enjoy positive and friendly and constructive relations with the people and with the government of Mauritius. We have much in common and many reasons to work together. For our part, we are always willing to sit down and talk to our partners about contentious bilateral matters that divide us. Although our efforts so far have not been successful, I repeat that offer now to the government of Mauritius. This is a bilateral matter for bilateral talks. It is not a matter for an advisory opinion to be given to the General Assembly. The United Kingdom has always been and continues to be a strong upholder of international law. We are not opposing this resolution because we have changed our principles, nor because we believe the rule of law does not apply in this case. Rather, we oppose this resolution because referring a bilateral dispute to the ICJ is not the appropriate course of action. So in conclusion, Mr. President, for all of these reasons, we strongly oppose the draft resolution. A request for an advisory opinion would be a distraction and, I fear, an obstacle to the path of bilateral talks, which is our preferred course of action. And it would set a terrible precedent, both for this Assembly and for the Court. If Mauritius will not withdraw it, I urge members to vote against the resolution. Thank you, Mr. President.
And I thank the distinguished permanent representative of the United Kingdom, and I give the floor to the distinguished representative of the United States.
Mr. President, the resolution before us today seeks to place before the International Court of Justice a bilateral territorial dispute concerning sovereignty over the Chagos Archipelago, which the United Kingdom administers as the British Indian Ocean Territory. By pursuing this resolution, Mauritius seeks to invoke the Court's advisory opinion jurisdiction not for its intended purpose, but rather to circumvent the Court's lack of contentious jurisdiction over this purely bilateral matter. The United States has consistently recognized United Kingdom sovereignty over the Chagos Archipelago, which has been under continuous British sovereignty since 1814. For nearly 4 decades, the United States and the United Kingdom have operated a military base on Diego Garcia in the Chagos Archipelago, which contributes considerably to regional and international security. The General Assembly's power to request advisory opinions is an important one. It allows the General Assembly to seek assistance from the ICJ in carrying out its functions under the UN Charter. However, we must be cautious not to allow this important power to be misused for political gain of individual states. While Mauritius is attempting to frame this as an issue of decolonization relevant to the international community, at its heart it is a bilateral territorial dispute, and the UK has not consented to the jurisdiction of the ICJ. Were Mauritius's request to proceed, it would undermine the Court's advisory function and circumvent the right of states to determine for themselves the means by which to peacefully settle their disputes. Any state currently engaged in efforts to resolve a bilateral dispute should vote against this resolution in recognition of the risk that supporting it suggests that any such dispute could be referred to the Court in this manner, without a state's consent, when the other party does not like how talks are proceeding. Establishing such a precedent is dangerous for all UN member states. It could lead to normalization of litigating bilateral disputes through General Assembly advisory opinion requests, even when a state directly involved has not consented to the jurisdiction of the ICJ. If, despite these serious concerns, this resolution is adopted, the ICJ would need to consider whether it would be appropriate for it to respond to this request. In our view, it would not. The advisory function of the ICJ was not intended to settle disputes between states. A decision to refer this dispute to the ICJ would also interfere with ongoing efforts to achieve a solution through bilateral channels. As our UK colleague has discussed, the UK has engaged in extensive and ongoing dialogue with Mauritius in an effort to address Mauritius's stated reasons for pursuing sovereignty and has made reasonable offers to Mauritius. We regret that Mauritius has chosen to circumvent these bilateral talks, and we continue to believe that this issue can only be addressed through efforts from both sides to negotiate a solution in good faith. For the foregoing reasons, the United States will vote against this resolution and encourages all member states to do the same. Thank you.
I thank the distinguished representative of the United States, and I now give the floor to the distinguished permanent representative of India.
Mr. President, when the United Nations was established in 1945, more than 7 decades ago, almost a third of the world's population lived in territories that were non-self-governing and dependent on colonial powers. As a country that has gone through the throes of decolonization, India, since its own independence in 1947, has always been in the forefront of the struggle against colonialism and apartheid. India was a co-sponsor of the landmark 1960 Declaration on the granting of independence to colonial countries and peoples, adopted by the General Assembly, which proclaimed the need to unconditionally end colonialism in all its forms and manifestations. In 1962, India was elected as the first chair of the Decolonization Committee, also known as the Committee of 24, that was established to monitor implementation of the 1960 Declaration and to make recommendations on its application. We still continue to be an active member of that committee today. Our ceaseless efforts, therefore, to put an end to colonialism are now a matter of record. Mr. President, as a result of sustained collective efforts by the UN membership, today, fewer than 2 million people live in non-self-governing territories, according to the United Nations documentation. Since the creation of the United Nations, more than 80 former colonies have gained their independence and have taken their rightful place in this august assembly here. However, the process of decolonization that began with our own independence still remains unfinished 7 decades later. In fact, in 2011, the General Assembly proclaimed the decade 2011-2020 as the third international decade for the eradication of colonialism. We would like to see a conclusion to this long-drawn process. Having said that, Mr. President, India shares with the international community security concerns relating to the Indian Ocean. We are conscious of our collective commitment towards ensuring the security and prosperity of our oceanic space. On balance, however, it is a matter of principle for India to uphold the process of decolonization and respect for sovereignty of nations. As part of our long-standing support to all peoples striving for decolonization, we have also consistently supported Mauritius, a fellow developing country from Africa, with whom we have age-old people-to-people bonds in their quest for the restoration of their sovereignty over the Chagos Archipelago. Mr. President, continuing with our consistent approach on this important issue of decolonization, India supports the draft resolution contained in document A/71/L73 proposed by Mauritius and co-sponsored on behalf of the states that are members of the group of African states, and will vote in favor of it. I thank you, Mr. President.
And I thank the distinguished permanent representative of India, and I now give the floor to the distinguished permanent representative of Egypt.
Mr. President, my delegation will vote on the draft resolution under consideration today based on the following reasons. First, the commitment to the common African stance towards this issue as reflected on the relevant resolution issued by the African Union Summit in January 2017. Second, the commitment to the NAM towards this matter as contained in the final communiqué of the NAM summit, which was held in the Margaritas Island in September of 2016. Third and last, this issue is one of the still pending issues that stand in the face of ending colonization. So we hope that we would find an appropriate solution to this matter according to the UN Charter and the principles of international law. Thank you, Mr. President.
And I thank the distinguished permanent representative of Egypt, and I now give the floor to the distinguished representative, the permanent representative of Kenya.
Mr. President, Kenya aligns itself with a statement by the African Group and the Non-Aligned Movement. Kenya joins all 54 of the members of the African Union in voting for the resolution A/71/L-73 on the separation of the Chagos Archipelago from Mauritius. For Kenya, this vote is a historical imperative in solidarity with the sister African nation, an imperative born of the suffering and the blood that was shed in the struggle for our country's independence and the upholding of freedom, liberty, and human rights in Africa and everywhere. The solidarity of the African Union on this matter signifies and exemplifies the depth of concern for the swift, permanent, and peaceful resolution of this matter of the Chagos Archipelago. And ministers and in the national sovereignty of Mauritius over its rightful historical territory. The historical injustice and the deep scars of the human rights abuses that have accompanied the occupation and exploitation of the Chagos Archipelago demands that all nations who believe in the principles of the United Nations Charter should stand up to be counted in support of this resolution. After all that is being asked of here is an advisory opinion from the International Court of Justice, a mere advisory opinion from an international court that we all respect. What can be possibly so unpalatable about that, Mr. President? And you see, Mr. President, there can be no difference, indeed no moral or ethical space between commitment to human rights today and the correction of grave historical injustices that have been perpetrated in the past, no matter how embarrassing and no matter the cost. We believe that our civilization and our membership of the United Nations demands this of us. I thank you.
And I thank the distinguished permanent representative of Kenya. And I now give the floor to the distinguished permanent representative of Tanzania.
Thank you, Mr. President. Mr. President, my delegation appreciates the leadership for calling this meeting. It's timely that we consider the matter on the table following the consultations and communication by contesting parties. Mr. President, today we are convening to consider the process of Chagos Island submitted by the African Union. My delegation aligns itself to the statement made by NAM, African Group, and Southern African Development Community. In principle, Tanzania believes that the processes of decolonization is essential and that consultation is a recipe for solution wherever disagreement among parties takes place. The argument of both sides demonstrate that there have been consultation and a bilateral arrangement to resolve the matter. Following this meeting, and the statement made by United Kingdom, my delegation feels that time has come for the two countries to convene and address the process of decolonization of the Chagos Island. In conclusion, my delegation wishes to encourage parties concerned to resolve this remaining process of the Chagos Island. Tanzania will join other African countries in support of Mauritius. Thank you.
And I thank the distinguished permanent representative of Tanzania. We've heard the last speaker in the debate on this item. So we're now going to proceed to consider draft resolution A/71/L73. In connection with draft resolution A/71/L73, I'd like to give the floor to the representative of the Secretariat.
Thank you, Mr. President. The present statement is made in accordance with Rule 153 of the Rules of Procedures of the General Assembly, and it is also made available on the PaperSmart portal. The implementation of the mandates contained in draft resolution A/71/L73, entitled Request for an Advisory Opinion of the International Court of Justice on the legal consequences of the separation of the Chagos Archipelago from Mauritius in 1965, would give rise to additional resource requirements under the regular budget. However, the work associated with rendering the requested advisory opinion would require further assessment and consultations with stakeholders in order to determine detailed related costs. Accordingly, it's not possible for the Secretariat to determine, at this stage, the full extent of the program budget implications arising from the draft resolution. However, based on precedents set by recent advisory opinions delivered by the International Court of Justice, it is estimated that the cost of an advisory opinion concerning the Chagos Archipelago could range from approximately $450,000 to $600,000. Should the General Assembly adopt the draft resolution, the Secretary General would submit a detailed revised estimates report for the proposed program budget for the biennium 2018-2019 to the General Assembly for its consideration at the 72nd session. Thank you, Mr. President.
Very good. We'll now proceed to explanations of vote before the vote. Before giving the floor for explanations of vote before the vote, may I remind delegations that explanations of vote are limited to 10 minutes and should be made by delegations from their seats. Looking at the clock, I can tell you that I will enforce that 10-minute limit per speaker. First on my speakers list, in explanation of position before the vote, United Kingdom delegation has the floor.
Thank you, Mr. President. The Assembly will understand that for the reasons given in my statement earlier, the United Kingdom strongly opposes the draft resolution. I will not repeat all those reasons now. However, I must underline again that this is a bilateral dispute between two states, the United Kingdom and Mauritius. Both the UK and Mauritius have excluded disputes with other Commonwealth states from their acceptance of the compulsory jurisdiction of the ICJ. This resolution is therefore a backdoor route to the court. The General Assembly is being used to cut across the principle that states are not obliged to have their bilateral disputes submitted for judicial settlement without their consent. Doing so would set a dangerous precedent, and it would be an obstacle to bilateral discussions, which are the right way to resolve this dispute. We therefore call all members of the Assembly to join us in voting against the resolution. Thank you, Mr. President.
I thank the distinguished permanent representative of the United Kingdom, and I give the floor to the next on my speakers list, the distinguished representative of the United States.
Mr. President, as we stated in our remarks, the United States continues to view this as a purely bilateral matter that would have more appropriately been resolved through continued diplomatic engagement. Voting for this resolution will set a dangerous precedent suggesting that the General Assembly could refer a bilateral dispute for an advisory opinion anytime one party chooses this path over engaging in good faith negotiations. We urge all member states to carefully consider the consequences of such a decision and to vote no on this resolution. Thank you.
I thank the distinguished representative of the United States, and I now call upon the distinguished representative of Chile.
Muchas gracias, presidente.
Thank you very much, Mr. President. With respect to item 87 on the agenda concerning the request for an advisory opinion of the International Court of Justice on the legal consequences of the separation of the Chagos Archipelago from Mauritius in 1965, Chile would like to inform that we do not associate ourselves with the statement made by the Bolivarian Republic of Venezuela as chair of the Coordinating Bureau of the Non-Aligned Movement due to the reservation expressed by our country under the second chapter of the final document of the 17th summit of the NAM conference, which took part in Margarita Island in September 2016. Chile bases its opinion on international law, whose values and purposes are a guarantee for the sovereign equality of states, as well as their integrity and the peaceful settlement of disputes. Chile has promoted and continues to promote the rule of law as a pillar in international relations. And due to this principle, Chile takes note of the request for an advisory opinion of the International Court of Justice on the legal consequences of the separation of the Chagos Archipelago from Mauritius in 1965. And this could be done on a bilateral basis in compliance with the norms of international law. Chile observes as well that the question posed by the Republic of Mauritius points to a solution which is defined within the decolonization process, where there is an interest of the international community, and it should be channeled within the terms and principles in Resolution 1514 of the General Assembly. And for this purpose, Chile will abstain in voting on the resolution. Thank you.
And I thank the distinguished permanent representative of Chile, and I now call upon the distinguished permanent representative of Croatia.
Thank you very much, Mr. President. Croatia remains a strong and univocal advocate of decolonization and firmly supports the respect for resolutions to that effect adopted in this August Assembly, including the pivotal one on the granting of independence to colonial countries and peoples. At the same time, as regards bilateral disputes between states, we believe in proper application of international law and the use of appropriate avenues in addressing such disputes. In this vein, as the jurisprudence within the architecture of applicable international law must be stable and predictable, so must be also the way on all outstanding issues. Thank you.
I thank the distinguished permanent representative of Croatia, and I give the floor now to the distinguished permanent representative of France.
Monsieur le Président.
Mr. President, the situation at the heart of this draft resolution presented by the African Group is a bilateral dispute. We only wish for its being solved. We have recalled for several months for our Mauritian and British friends to find a solution through negotiation. We regret that they have yet to reach this agreement. We believe, however, that the possibility offered by negotiation have yet to be fully used. Therefore, we are not convinced that the adoption of a request for an advisory opinion of the International Court of Justice would facilitate such a solution. An issue of sovereignty between states, as is this case, should be regulated within the principle of an agreement amongst states to be judged. We must all ensure the respect of this principle that the ICJ has considered a fundamental principle. This is why the French delegation is not able to vote for this draft resolution. We nevertheless wish to express our hope that the parties in this dispute will continue in good faith towards a solution. We hope in the near future that the parties will be able to reach an appropriate solution, one that will be appropriate for them and their friends and partners, which include France. I thank you.
And I thank the distinguished permanent representative of France, and I now call upon the distinguished permanent representative of Trinidad and Tobago.
Thank you, Mr. President. Trinidad and Tobago wishes to give the following explanation of the vote prior to the vote on item 87. Request for an advisory opinion of the International Court of Justice on the legal consequences of the separation of the Chagos Archipelago from Mauritius in 1965. At the outset, Trinidad and Tobago wishes to reiterate its commitment to the non-alignment and the peaceful settlement of disputes. At the same time, we also recognize that the opinion of the court is not binding and serves to further advance international law and bring about an independent solution to the issue at hand. For these reasons, Trinidad and Tobago will vote in favor of the draft resolution.
And I thank the distinguished permanent representative of Trinidad and Tobago. We have now heard the last speaker, an explanation of vote before the vote. Assembly will now take a decision on draft resolution A/71/L73 entitled Request for an Advisory Opinion of the International Court of Justice on the legal consequences of the separation of the Chagos Archipelago from Mauritius in 1965. For your information, the draft resolution has closed for e-sponsorship. I now give the floor to the representative of the Secretariat.
Thank you, Mr. President. I should like to announce that since the submission of the draft resolution, and in addition to those delegations listed on the L document, the following countries have also become co-sponsors of A/71/L73: Argentina, Bolivia, Cuba, Ecuador, Nicaragua, and Venezuela. If any other countries wish to co-sponsor A/71/L73, please signify by pressing the microphone button now. No further request. Thank you, Mr. President.
Okay, a recorded vote has been requested, and we shall now begin the voting process. Those in favor of draft resolution A/71/L73, please signify. Those against and abstentions.
The Assembly is now voting on draft resolution A/71/L73. Please, will all delegations confirm that their vote is accurately reflected? Please lock the machine. Okay. 94. 94 in favor.
Where's the law? Is that an adoption or not?
Yes, it's adopted.
As you can see, the result of the vote is as follows. Those in favour, 94. Those against, 15. Abstentions, 65. Draft Resolution A/71/L73 is adopted.